American Realism. So this American Realism that we are going to go into today would cover an area that is being promoted by the American judicial landscape. Yeah? So they are the one that, what they call it, the proponents of the movement, where we have these judges who portray that the interpretation of law should not be given by virtue of the law, meaning by the parliament. They just don't act as the agent of the parliament, but they are themselves the one that really understand the law, and therefore they are the one that decide whether the law is the law or not. You know, you can always come up with an act. You know, the parliament can always come up with an act, but the act is useless unless and until the law is being applied by the judges. Now, our concentration would be looking at how judges come up to their decision making. Obviously, in the MLS subject, you have learned about the interpretation of judicial interpretation, kan? The apa yang you belajar? Judicial interpretation, judges. Judicial interpretation, guys? I still remember.
Sir, it's either strict approach or liberal approach.
Tak dengar.
Strict approach or liberal approach.
Liberal approach dengan
strict approach.
Strict approach. Okay. We have the rules that is being applied, kan? Kita ada golden rules, mischief rules, you know. Lagi kita ada there's 4 rules that it is being applied, in order for the judges to come up with their decision. Now, the jurisprudential perspective that we are going to learn is somewhere along that line, yeah, where judges, in order for them to give judgment, obviously, if you look at the formal way that they are supposed to do their job, is to just interpret the law, right? Just to interpret the law, and they are lawgivers rather than lawmakers. They just try to give some justice by virtue of the decision making that they are going to do. So, but later, these jurists, American judges, they say that actually they are even better to make decision in terms of which law is proper and which one is not proper, because at the end of the day, they are the one that is going to make the decision, right? So their decision is reflecting on their understanding of the law. If the law that is being created by Parliament is something that is not useful, then obviously the judge, even though with the presentation of the solicitors for both parties, the judge will only choose the one that he or she likes, and it's not about liking, but it's about understanding of that particular law in order for the law to be used as within the what they call decision. So if you look at any ratio decidendi of a judge within a case, then you start to see their understanding of the law. So basically what I'm trying to say is that law, according to American jurists or American realism, is looking at the reality of things. Yeah? As far as courts is concerned, the decision making that they have made so far is actually reflecting they are the one who knows the law. They are not just otherwise we can utilize AI to replace judges, right? If it's so simple to identify, to give a real artificial intelligence, a robot replacing the judge, just because you just need to identify the provision of the law, whether uh, how long you should punish, what are the evidential thing that needs to be done in order to prove whether that person is lying or correct or not, so if it's so technical, then what's the point of engaging someone of that stature? So might as well put a robot there. But it turns out that it is not that. It is more than that. Okay. So if you look at this first slide, we are going to cover three areas: American realism in terms of its definition, some background about it. Then we look into Holmes, Llewellyn, and Frank, Jerome Frank. Okay. I have to keep on doing this because nanti orang tak boleh masuk. Right. So that is the first area, the area that we are going to cover. The first area, let's look at American realism or legal realism. So as I already mentioned, law is actually exists in practice rather than how it exists in books. So if you look at the nature of how law is being applied, it's not of a matter of what is being written down. It is not about judicial precedent. It is binding judicial precedent. It's not about what they call it, the system. It is not about the technical thing. It is about the reality of things, how it is being practiced. Law is based on what is being practiced in the court. So who are practicing the law in the court? Judges. Okay. Judges are the one that is making the decision whether, as I already mentioned, the law is the law because he or she said so. So that is just to give you a bird's eye view. You can stop me at any time asking me question, yeah, guys? Okay, that is okay. The position, you look at the position, if you look at the position of the slide earlier, right, where in the whole area that we are studying, actually, it is not in a way that is about how the law is being formulated. We have studied under Juris 1, trying to formulate the law, trying to think about how the law comes about. Say, for example, if you look at classical philosophers, Plato, Aristotle, so they are looking at the foundation of how law is to be created. Okay, this normally jurist one, if you look at positivists, naturalists, the argument that they came up with in order for the law to be created must have some underlying foundation. One group says it must be natural, another group says it's positivist, another group say it is historical. That is the interpretation of what law should be. Or is formulated. And then the other one, if you look at the right side, here we see that it is not about the outcome, where obviously we are talking about a judge. Whenever the judge make a decision, obviously it will be impacting the society. However, if you look at Roscoe Pound, if you look at the Scandinavian that we have done, they are more towards outcome. Okay, their worries or their thinking about the function of the law is about the ability for the law to produce good outcome. Okay, so macam Roscoe Pound, you foresee, you forecast, you anticipate that the society is going to be better, and you do your groundwork in order for you to find the best solution. So their focus is towards society. But if you look at American realism, is basically is looking at the what do you call it, the case that is in front of them. Okay, though they make the decision that is going to impact the society, and obviously they are people who are aware that their decision is going to have an impact to the society. But the moment that they choose whatever law that needs to be taken in order to verify or validify to make their decision, uh, that is where they are. Yeah, that is we are talking about the position that the reality of things happens because they are the one that makes decision. It is not about planning future law or future outcome. They are not planners. By the things that they are doing with the cases that goes into their courts, they are the one that is going to change the society. Say for example, a person that commit crime second time, third time coming to the court, that decision of the judge over that particular case is going to have an impact towards the society. Though lower courts nampak macam sikit, tapi the upper courts will be more significant. Right? The impact of the decision of federal court judge or Supreme Court judges, they are going to be very significant. So throughout the world, this is the movement that says that the judges are the one that should be taken seriously. Yeah, taken seriously, and they are the one that is very important to the society in terms of the decision that they are making. So this is what we also call under the one that you have learned, uh, especially in Consti law, Consti 1, Consti 2, about judicial activism. Okay, if you Google judicial activism, it is a method ataupun is a study about how judges portray themselves. They are the one that is able to be realistic going into the society in terms of their cases that they are doing and change the society. So we have Tun Saleh Abbas, Tun Sofian. Those are champions of judicial activism in Malaysia. We are going to cover this topic again under the final topic. Yeah. So this particular area of American realism is an input for you to discuss the function of the judiciary when it comes to that particular topic. So coming back, clear everyone about the function of the judge. Basically, it is about law giver. It's not only lawgiver. It is about the lawmaker. They are the one who is going to make the law. So basically, the thing is, it started in the 19th and middle of 20th century, and realism is antithesis of idealism. Idealism, as you have learned in Juris 1, is about idea, it's about theory, it's about concept. It is not about that. It is not about Juris 1. Okay? American realism is based on reality of things. Okay, so reality rather than idea. So some people like jurists like Max Weber refused to accept the realist school as the separate school of jurisprudence because there is no proper methodology. Yeah, so there is no proper methodology. It's just that they are saying that look at the reality. We are the one that is being put to decide of a problem in the society, whether it is murder, whether it is rape, whether it is breach of trust, criminal breach of trust, or any other issues. They are the one that is going to be the one that is important. So their main concern is the law on how it is being used by judges. It is a movement of analytical positivism and sociological approach combined. So analytical positivism ni macam mana? You've learned in Juris 1, positivism is about Austin, it's about Hart, it's about Kelson. Those are the positivism. It is similar to that, but all this positivism, they have their own way of looking at law. Yeah? Say, for example, Austin says command theory. Okay, Austin says command theory. He says law properly so-called, law not properly so-called. Then you have that division, between God's law and command, so those element is based on analytical, because you have to analyze. You look at the certain situation and then you have to analyze it. What do you mean by sovereign? Who are sovereign? What is command? What is sanction? And then you see hard, talking about primary. What is primary? What is secondary laws? That is analytical positivism. It is in a sense ideological idealism, but it has its structures that they have, what do you call it, that they have laid out in order for you to really understand what is positivism. So you have to analyze in terms of legal principle and rules, according to American realism. So you have to look at the legal principle, rules, and analyze concept, relationship towards the ideas of the legal system that we have regarding person, obligation, right, duty, and acts. Okay, these acts are, to me, I would see it as tools for judges. Okay, so tools of judges about the principle, let's say, for example, the formulas that you have, the test in law of thoughts, how to determine whether a person commit assault or battery or trespass. There would be tests that is needed to be applied in order for the judge to come up with solution. So does with every other laws. Yeah. So if you look at apa, sales of good, and then you have the let the buyer beware, the principle that is being used, those are the things that are considered as tools. Yeah? But tools are very important for analytical positivism. In order for American realism to apply it, they will be in that nature. And then the other one is sociological. Yeah. So what do you mean by sociological? Because they are the decision that is being made by judges are very important to the society, because it produce outcome. It change the society makeup. Say, for example, I can give you an example of Donahue and Stevenson, okay, and law of thoughts, negligent, right? Because of the case itself, it changes the whole structure of how businesses is to be conducted. You cannot produce a product without the ability for you to scan or check the product before it is being sold to others. So if it's were to be found out that the product that you produce are substandard, you know, people can always take you to court, and chances of you to be liable is very high, because the principle is already there. You know, you are not to injure your neighbor, because you, as the producer of any product, you must foresee that the end user, somebody out there, is going to use your product. Otherwise, you don't produce your product at all. But since you have produced it, you must anticipate that somebody will use it. And if you produce something that is substandard, that is very unhygienic, so you or going to cause some reaction to somebody, then obviously you are going to be responsible. If they can prove that you owe a duty towards them, which is very simple, and the fact that you fail to do your duty to maintain your standard of care, then obviously you're going to be responsible if they can prove that you are the one that caused the illness that they suffered. Okay, so that is sociological in nature, because from there onwards, now every manufacturing company have what we call pre and post, checking. I used to work with the manufacturing factory company, where we check the product, the raw materials. We check the raw materials, whether the raw materials is proper or not. And within the process of manufacturing, we also check whether the product is up to the standard. And when you have finished good, you also have another checking. So we call it QC. Yeah, I think you're familiar with QC, quality standard. Yeah? These are the units that or departments that is created in any manufacturing company to check the standard of the process of manufacturing from one stage to another. So it is in a way that I'm trying to say is that it is sociological in nature because the outcome is going to be impacting the society. So judges are in that manner. So they are both, this movement is both analytical and analytical positivism and sociological. They don't give any importance to law enacted by legislature. They don't care. You can come out with any laws. It's up to you. You know, you do your job. But when it comes to judges, they are the one to identify whether the law that is being created by the parliament is genuine or not. Yeah, at the end of the day, they are the one to decide whether that particular law created by parliament is valid or not. You have seen cases that the court reject, yeah, or says that this particular law is unconstitutional, this particular law is against the provision of the another current act. So whatever rules that is being created or by legislative or administrative, because administrative they are the ability for them to create bylaws, betul tak? So because Parliament would normally issue basic law, which is act, but this act is giving power to the ministers or the departments, the ministry powers in order for the agents within the ministry to create new laws, which we call bylaws. So that bylaws can be challenged in court, and the court will be the one that is giving the final say whether the law created by either the parliament or by the executive is valid or not. Okay, so this is because only judges understand about law. Okay, that is the reality. Yeah, we are talking about judicial realism, kan? So here, judges, you cannot run away that they understand the law. It is not about the creator, the administrator. Obviously, if you see situation that is happening, they create law in order for them to utilize the law and make their work faster, easier, things like that. But the one that is going to evaluate whether that particular law is infringing into somebody else's right or conflicting with another laws would be the judges. Okay, and they understand the society because they are the one that is in and out every day dealing with the problem of the society. People in the parliament, they don't see the problem of the society. All the dirty things that is happening in the society will come to the court. Yeah, nobody is going to celebrate things in the court. Uh, obviously, yeah. So the courts are a place where you see all the dirty things of the society. So they are the one who knows about the society, what is happening, and also their psychology effect and any judgment given by them. So they knew how it would be reflecting towards the criminals or the people that they are making decision on. Okay, the impact of their decision, they knew, they can see the impact of their decision, and they with the experience, after 20 years of being a judge for maybe about 30,000 cases, obviously you tend to know what needs to be done or the impact towards people. Sometimes they are lenient, sometimes they are very what do you call it, strong in their decision because they know the impact. I like to go to YouTube to look at how judges, the camera session of showing how judges make their decision and the thing that is happening in their courtroom. Sometimes you see bursts of negative things that are happening. Then it is something for us to actually ponder about. Kalau I don't want to be a judge because what a miserable life it is to me lah. You cannot do things, and you are facing with evil people, and they are not happy with you. Sooner or later, they will, if given a chance, they will take action against you in a criminal way. But life has to go on. We need people to be there, brave enough to 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 face the challenge of the society. Okay, so that's in the same case, applying the same law, two different judges can give two different, sorry, uh, two different judges can give different judgment, right? So it is from two different judges making two different judgment is a clear indication that they understand the law. So they can agree to disagree. Okay, this is my opinion, this is your opinion. We agree to disagree, and let the process will take up its due course and come up with the real answer. So they also denounce traditional legal rules. So I need to have something that is automatic, otherwise I have to keep on. Okay, they denounce traditional legal rules and concept, lawgiver than lawmaker, and concentrate more on what the court actually do in reaching the final decision of the case. Yeah. So they are more what do you call it, daring. Yeah, they are more daring in terms of to say actually we are the one who is actually making the law, because we decide which law is to be relevant or not. They define law as generalized prediction of what the courts will do. Okay, so law is nothing of a black and white, nothing in a way that it is so clear that when it goes to the process of judicial process, it will come out as what you anticipate it's going to be. So if you have a contract case between your client and the other person, when you see on the letters of or the evidence that you have, you might think that the evidence that you have might lead to a winning of the case. I don't think so. Yeah, because it can turn the other way around if you go under the process of judiciary. You know, if you go to the court, nothing is predetermined. Yeah? You cannot say that the law is very clear uh, on this matter. You cannot be so confident. Why? Because when it comes to court, you don't know what is going to happen, right? Because at the end of the day, the final say or final verdict of the judge for us, Malaysia, we have to look at how judges come about with their decision, you know. And they believe that certainty of law is a myth. Yeah? Uh, what do you mean by certainty of law? It's something of a myth, something of a something you cannot rely on, and its predictability depends upon the set of facts, which are before the courts for decision. It's all based on facts. Say, for example, the police have already captured a person for uh, uh, drug trafficking. You know, it went to the court, and the court look at the evidence and say that it is admissible, you know, admissible in court, and reject. So there goes your case. You know, that is where AG, in order for them to bring the case to court, they have to really make sure that the probability of winning is there, yeah, and to make sure everything is in order. Judicial activism of the courts, they reached the peak under the time where Franklin Roosevelt, where we have economic recession, the Great Depression, they say, where we have New Deals created by the president. He is so desperate to change the economic of the United States, where he put in New Deals, where projects was given, decision was made. The executive was very, very powerful at that point of time. But here comes the courts, the Supreme Court coming and saying that, excuse me, you don't have that power. So some of them go to the to declare a certain act by the president was unconstitutional. And another example that I'm giving here is that the case of Nixon, the President Nixon, here in United States, and Nixon is the regarding the Watergate scandal. You can see the movie of Watergate scandal about what happened. The Nixon utilized the position in order to attack the opposition in order for him to make sure that he is re-elected. So as a result of that decision by the court, he actually resigned, as U.S. president. Okay, moving on, we look at Jerome Frank. This is just giving an example, looking from Jerome Frank, one of the jurists. He says that law is what the court has decided in respect to any particular set of facts, as I already mentioned, about facts prior to a decision. The opinion of lawyers is only guessing. Yeah? So if you are ending up yourself as a lawyer later on, when you go to court, you can only guess. Yeah. So don't really give the answer to your client and saying that it's a sure thing, unless and until it is being said so. Yeah, as to what the court will decide, it's just a matter of guessing it, and this cannot be treated as a law unless the court so decides. Yeah, so in the judicial pronouncement, kalau the legal apa kata judgment, so if the court is favoring you, that will be the day that you say lega, finally. You think that you might win, and you try your best to present your case in order for the judge to be on your side, and it will be something of a relief, when the judge do be on your side under the judgment that he or she is making. So that is based on reality. Yeah. So you cannot say that, oh, judge, you have to follow this. You cannot, because he is or she is given that stature or given that avenue to choose and to come up with their decision. You can appeal if you are not happy with their decision. But as far as you cannot dictate the judge and looking at, my lord, this is the law, you have to follow the law. You can do that, but chances are, if it is misleading, if the judge is really off, of the law, meaning not abiding to the law, you can always appeal, right? Okay. Uh, let's look at the juries. We have three people. There are many here, but we are looking at only the major one. Holmes, Llewellyn, and Frank. Okay, before we go in, any question? Any question, guys? The strict legal approach and liberal approach. Yeah, okay. Okay, if there is none, so we proceed with Holmes and Llewellyn. As I already mentioned, they did not come out with any theoretical framework, or any specific way. So that is why I stated that Max Weber says these people are not something that we can recognize because they don't have any foundation. Even though they are talking about reality, but law is about something that you can stick on, you can follow, something that you need to be able to say that this is the law. Macam council kan, so they have the legal norm, what is grand norm. So at least there is a process of identifying, because you can apply the theory in any situation in any country, then you will see what is law. Okay, so this group of people is just a matter of showing the reality of things. So here we have Oliver Holmes. He is the Associate Justice of Supreme Court. It's from 1902, 1932. A very influential person. He is described as intellectual inspiration and even the spiritual father of American realist movement. And for that, the father of judicial movement throughout the world. Home was skeptical because they don't worry about their position. Yeah, so obviously you do have cases in American history that judges go against the executive. Obviously, they are going to be reprimanded because of their vocal, But we are looking at this proper movement. Yeah. So Holmes was skeptical of the ability of the general rules to provide the solution to particular cases and readily gave authority to the role of extra legal factors in judicial decision making. Meaning, he is a skeptical person looking at how cases is to be decided. And there is no hard and fast rule about a case to be decided in a specific way. Okay, so there is an authority for the judiciary, meaning the judges, in terms of their role that they are playing, which is an extra legal factors, yeah, in the decision making itself. So they are decision maker, but at the same time they are lawmaker. Yeah. So Holmes gave the first and classical exposition of the court focus approach in 1897, sowing the seeds for realism in his paper The Path of Law. So you can read it up, Path of Law. You can Google it online, and you see the foundation of what he is trying to say. So you might see it as biasa, normal. That is what we are looking at today. But back then, it is totally different. Okay, judges are just merely a stamp pad, yeah, stamping pad of a case. They just apply the law and stamp it. Yeah, they are not the one that is creating new laws. Right. Moving on. Oliver Holmes' life of law is experience, not logic. Yeah. So logic does play a role, but it is more of an experience. Okay. If you apply logic, then you are applying standard rules, standard formula. But actually, application of the law is all about experience. Law is prediction of what the courts will decide, as I already mentioned. Something that you can forecast or foresee. If, say, for example, a man coming to the court for rape cases, the judge is a woman, mati, you die. You know, the chances of you getting punishment, higher punishment than the bias is going to be there, obviously. You know, being judges as people, and they are the one that is creating law to to formulate or to to produce society, to change the society in their own perspective. If you have a rape person, a repeated offender, rape to a judge that is woman, chances are, you are going to face a decision that is going to be affecting your status. Now, legal history is to be studied to understand how rules develop. How rules develop, not just because they are being laid down by this. What he said was Henry the Fourth, meaning it is not something that is being bestowed down by the judiciary. Sorry, by the legislative. Legislative are not the one that is dictating the court system, dictating the judges. These are the things that you need to do. We created the law, you just follow the law. No, it is not like that. Law must be strictly distinguished from moral, because when it comes to reality of things, the judges would see as law not being as of morality. It is more of a serious thing, which is nothing got to do with morality. Here he says that uh, if you look at the cart before the horse, It doesn't make sense. You cannot put theory in front of the judge. It must be theory and before the horse itself, before the judge. So the judge is the one that is leading the theory. You can come up with theory, you can come up with the law, you can come with some process and procedures, but actually the judges will be the one to lead the process. Okay. Right. What is constitute law? Law is not based on system of reason or ethics. Yeah, it cannot be in a way that it is based on idealism, reasons. Based on natural law, or maybe because the morality that the law needs to have. No, it is not about that. We're looking at the reality of things that is happening in the society that the courts will play a big role. Law is a prediction of how courts behave. I already mentioned that. This is similar to a Batman theory. Yeah, a Batman person. Here it is being stated as a Batman theory. Why he is saying a Batman theory? Because if you take a Batman person that goes to the court, he doesn't care about things, which law to apply, which rule that is going to be impacting him or her. As a bad person, he is only having one concern, which is the outcome. He wants the outcome to be favoring himself. So that is what they call it, Oliver Holmes is saying about the law. If you look at the law from the perspective of American realism, is about the outcome. It's not about what law, what evidence, what material, what witnesses. No, no, no. It's not about that. It's about the outcome. So law is simply about staying out of jail and avoiding payment of damages. The courts therefore functions the same. Okay. So if you look at judges, they don't really they just want to get the decision made over or the problem that faced in by them in courts to be resolved. Okay, not to say that they are so easy in order for them to make that decision, but basically that is in their mind. If you are the judge, you have your list of cases. You have your KPI. Your quotas that you need to satisfy. Nowadays, because of the backlog of cases, the Chief Justice has already laid out that all judges they have KPIs. They need to maintain certain quotas that they are supposed to complete. So basically, it is not about discovering things. It is all about the issue of settling the cases as soon as possible. Okay, but, as uh, as good as possible lah.
Sir,
Yes, good.
I need a clarification on the Batman theory. Meaning,
Mm-hmm.
what Holmes is trying to say is when he says that law is similar to the Batman theory, it's just that these judges, when they take up the cases, it's just to fulfill a quota and they don't care about the law.
Mm.
I
In a way,
don't
in a
really
way,
understand.
okay. In a way, because if you are focusing on the outcome of your case, obviously you don't. It is not an issue for you to discover and investigate in a way that you try to find something that is better. Something that is better for you to do. Say, for example, I am going to change the system. I'm going to change the system to adversarial as compared to inquisitorial. Inquisitorial system like we have in Indonesia, where judges plays a major role into finding out about the case itself. So you take longer time in order for you to decide that your case whether the case is for or against. Yeah. So the role of judges in Indonesia is, as already mentioned, they took their own space in order for them to find the answer. But for adversarial system, that we ask the two parties in our system to fight, and the court will be the decision maker. So the judge is not supposed to inquire, but to analyze the evidence that is being put in his or her court to decide on that particular merit of the case. You know, so obviously the what do you call it? The intention or the reality of the judge, with regards to the law, is about getting the case decided as soon as possible, because there are hundreds of thousands of cases that is going into the court system daily. The system is handling thousands and thousands of cases, backlogs of hundreds of thousands of cases. So banyak sangat, so they have to cater that. In US, what happened is they have night courts. In night court, the courts, in order to handle cases, during the night, in order for justice has to be served. You cannot delay someone that is the fact that someone is in jail and not being able to be in court, and for the judge to decide whether he or she is guilty or not. So it is not fair. So it is more or less a process, a process that can be seen as a as soon as possible lah. You try to resolve that issue as soon as possible, just like what a Batman is having in their mind whenever they go to court. Okay, or Batman whenever they were to be prosecuted, obviously in their mind is, how do I get away from this? So the lawyer says here the evidence that he or she doesn't want to know anything technical about the case. Yeah, he wants to know that he is able to be freed at the end of the day. Now that is the Batman theory. So the same thing can be applied to the law. Yeah, if you're looking at American realism, law, according to Holmes, he says that law here is about the outcome rather than the process. Law is about the outcome rather than the process. So the parliament can say that these are the laws that you need to apply. The prosecutor would say these are the laws that is regarding this particular case. By the end of the day, law is actually what the judges is applying, because by the end of the day, they have to make decision. Boleh nampak the relationship between a bad person that is trying to run away from being punished. Their main concern is, aku nak kena penjara ke tak? The same thing with the law with regards to judiciary. So it is something along that line, to be able to have a final decision that is being made towards that particular case. Boleh tak?
Sir, thank you.
No, okay, good. All right. Moving on. Nampak tak? Dia tak ada structure. There is no formula, that you can follow. It's just a concept, This particular concept, Batman theory. What do you mean by Batman theory? Are you saying that the law is in merciless in terms of or wouldn't care less about what is happening? Not really, kan? Because they play a role. Nanti kita tengok ada juris macam mana they expand the Batman theory. Next is we have another I call it judge. We have Carly Willin, who says that a court is doing its duty when, with clear consciousness, that it understand what it is doing and why. So it is a consciousness factor that the court will have to apply. And obviously the court, if you look at cases, nampak macam dia kasar, they are making decision that is, you're guilty, you're going to punish, there is no sense of orang kata humanness. Yeah? But you have to look at their job. Their job is to be able to settle the problem as soon as possible, to deliver justice as best as possible. And obviously, why it is like that? Because they are conscious about their duty, yeah, and why they are doing. They understand why, and then why they are doing, yeah? What they are doing and why they are doing it. They know, okay, because you choose to be the judge. So obviously, you it's not about glamour, it is not about the pay, it is about delivering. Yeah. So, and with clear statement of both, it goes to back with the whole of the broad situation, meaning you try your best to resolve the societal problem. Yeah. So every, remember I told you earlier on that every judges will face the dirt or the mess of the society. Yeah, the mess of the society or the evil of the society will go to the court. And then if you, macam my wife, she refused to be a lawyer because she cannot handle the the system and the problem that is being faced. You know, the injusticeness or the problem that comes about with clients and things like that. So she doesn't like that. She refused to be a lawyer anymore. So that is why you look at judges. They are, you know, they are in a stressful position. Yeah, being as a judge, it is not easy to look at sickness of the society, and you have to be impartial, be professional in order for you to make your decision for the best interest of the injured party, the best interest of the what do you call it, the person that is guilty, to the best interest to the parties that is going to be involved, the family members or the society at large. So you can imagine a role of a judge. They live in a miserable life. I don't know, because study has not been done whether judges are happy or not with their lifestyle, because they cannot enjoy life, they cannot be with the society, they cannot, socialize with the society, because they have to be distancing themselves in order for them to be able to make decision without fear and favor. Okay. That is, he says about paper rules. Yeah? Paper rules and real rules are two different things. Okay, so they kata with regards to statute and precedents are just mere paper rules. They are just tools to be used. Real rules would be the one that is being discovered by the courts and trying to bring it to the light. Yeah, bringing the concept or the idea or the nature of the law itself, bringing it to the front in order for it to be highlighted and be a new tools to be used for another case. Yeah, as I already mentioned, you have precedent apa orang kata, binding judicial precedent cases, right? So we have landmark cases. Yeah, so those landmark cases are considered as real rules. Yeah, whereby it changes the whole situation. Okay, so that is where we in our classes, when you go to any classes, you learn about landmark cases. Yeah, it is very important for you to the lecturer wants you to remember those landmark cases because they are very significant. Why those landmark cases are significant? Because judges make decision. They really make the decision, and that decision makes sense. Yeah, because of the rationality, because of the way that the insight that they put inside their judgment. So I love to look at what do you call it, landmark cases, because you can learn a lot. Yeah, of what is in their mind. Uh, Tun Saleh Abbas, Tun Sofia, Raja Azlan, Lord Denning, Lord Atkin, Acton. So those are decision makers. Yeah, decision makers. They actually they create the laws. Okay. So paper rules did not explain the reason behind the process of judges when they make decision. It's just ratio decidendi, just provide merely paper justification, nothing else. Yeah? Real rules are therefore foundation of judicial decision. To understand why they are making that decision is something that is important for you as a lawyer, for the society to understand why the court is making that kind of decision. Okay? It is not for the people in mass media in saying that why court ni kira murtad lah, hakim is so evil, It is about understanding the reality of their decision. So dia kata kat sini, paper rules are predictors of the court's result. They just prediction. Paper rules fails because legal rules are made flexible for future application. Yeah? Because legal rules can be flexible and change, in the future, and it will be utilized as a tool to be applied later. Thus, lawyers are unable to predict judge decision. Because of that, lawyers are not able to predict judge decision. Paper rules fails as judges may not want to apply the rules. Okay, because you cannot force, as I already mentioned, you cannot force the court to apply the paper rules because the final say will be the judge. If you're not happy, then if you feel that the judge has made an error with regards to the application of the law, then you can appeal. And if you appeal, even when you appeal, you are subjected to that judge interpretation of that law. Okay, he can agree or disagree. And then it is the business of the law. Here, it is the business of the law to do something that is right. Okay, so anyone that is in charge with respect to sheriff, legal clerk, jailers, lawyers are considered as official of the law. Meaning, if you are the official appointed, then you have to do your work. If you have to do your work, it is sort of a business that you have to do. You have to be active. Doing your work and doing your business is something that is slightly different. It's a business of the law. Yeah, business of the law are the people or the agents that needs to play their role effectively to make sure that law is able to be delivered to the society. What they do in dispute is considered as the law. If they say, for example, disagree with one another, they go to court and fight it out, that is good. Because then the judge can come in and give the clarity, based on the experience or craftsmanship. It's about skills. It is about the ability of the judge to look at the problem and try to be creative, in terms of how to solve that particular problem. Law as an institution. Just now, law as business. Now, law as institution, according to Llewellyn, he says that the basic function of law as activities around a job or clusters of law jobs. Law is an institution whereby it is necessary in the society. We cannot run away because macam seolah-olah kita kata, you nak pakai kereta, you want to utilize the technology of cars. We need the manufacturers. We cannot simply say that I want to build my own cars. No, it doesn't make sense. It doesn't make economic sense. So what you need to do is to have a manufacturer to produce that particular product that you want. So the same thing with law as institution, whereby this institution is an institution that is very needed by the society, which comprises not only rules, but contain ideology or a body that are pervasive and powerful ideas which are largely unspoken. Things that you don't recognize, you don't really understand, you don't really probe, you don't really study, you don't really research about what is happening in the minds of the judge. Largely implicit, nothing is being done or to investigate, but it is there. You cannot deny that it is real, it is there, and which passed unmentioned in the books. Rarely people study that. Law has jobs to do within a society. It is the institution duty, as a legal institution, to play their role and to be able to be functioning in the society. Law as a law jobs theory. He says that law have jobs to do within the society. How trouble cases are handled, just like macam garage repair works. You have problem of towards your car, you bring it to the garage, and the garage man would be the one that is able to quickly identify what is the problem faced by you. You can obviously try to repair on your own, obviously, like mine. I used to, my motorbike is now naked altogether with all the bones. I've taken everything out. I would just like to explore and use YouTube to, to add things to my motorbike. But you are going to take longer time. You have to build up the experience. But to make things easy, just bring to the garage, and they are there, very experienced people who knows how to handle things quickly. How to channel conduct so to avoid troubles. Obviously, they are able to avoid troubles. If you don't know what you're doing, positive punya wire masuk dengan negative punya, you can cause fire. And the same thing with judges. The institution, the people that is working that is related to them are the one that is very, what do you call it, very related to the issue. How authorities are allocated and arrange of procedures. So it is about who do what, what are the powers that is given for each one of them. So if we have the lower judges and upper judges, magistrate, session court, high court, federal court, so things are being allocated to them in order for them to know what needs to be done. As you know, macam MLS, doesn't mean that killing can go to magistrate court. It will go to high court. Murder case and things like that. Because yes, they set the law. These are the cases, the crimes that is occurring goes to which court. But what happened in the court is up to the judges themselves, because they have a job that they have to do. How organization of society is providing to provide integration, direction, and incentive. Because this decision that they are making is going to impact the society. The integration of the society when it comes to the outcome of the decision that they made, or within the organization themselves, they have to do a fine tune of how people that is working there in the judicial system must function towards one another, and give direction towards one another to have a good outcome, or what do you call it, result. How to use a single slogan of juristic method. So all law jobs are done better until it becomes a source of new achievement. So it is what do you call it? Is ongoing progress, ongoing development of something that is for us to achieve. If it's a job, if you are going later on working as a person, earning a living, it is not only doing the job. If you were to do job properly, do it correctly, you should be able to implement certain measures that is improving your skills, improving your nature of jobs. Okay, so you improve your skill because you want to improve the job. Why do you improve the job? Because you want to save time, give more effective of your outcome of your work, to make more profit to the organization that you're working. So if you take it as a job, not as a worker. Kalau worker, they just do the job, they just go in and out, just do the job. Work that is considered as work. But if you really take it as a business, as an institution, as a job, then therefore you are going to work hard into improving that particular job to a better position. Okay, that is Holmes and Llewellyn. Sorry, I kena laju sikit lah. Habis. And then we have the third jurist, Judge Jerome Frank. You know, he is coming up with a little bit different the other formula sikit lah. Yeah. So he came up with rule skeptic and fact skeptic, meaning you are skeptic about the rules, you are skeptic about the facts. So this actually, if you look at the judicial system, the court system, you will see these two different perspective of how judges are to look at their cases. Yeah, I already mentioned the law jobs yang kat atas. Holmes talks about Batman theory. You know, so how it is being done. So in order for us to understand that the two jurists above, you have to look at the how it is the reality that is being done, and this is just one perspective lah. Okay, rule skeptic and fact skeptic, meaning rule skeptics are those who are in doubt that the rules of the decided cases. So they are, you know, looking at the rules and they are skeptic about the rules. Okay, so they are more looking at the facts rather than the rules. This is more towards the trial courts, meaning sekejap lagi I akan tunjuk kat bawah tu ya. It is more towards the lower courts. They are rule skeptic. They look at the facts more rather than look at the rules. You know, they look at a person that comes to their courts. This particular person, other facts lah. You know, if you have facts to provide evidence for the judge to make decision, and they will easily make their decision based on the facts. You know, if you prove evidence of injury, you prove evidence of substance, you know, if you're looking at drugs, you know, in possession, they don't question about that particular lady, why that particular lady was having drugs in her possession. Say for example, she was caught as a mule, you know, in drug trafficking. So somebody put drugs into her bag. It is not about trying to investigate, you know, what is happening. When she was caught, the issue of whether somebody has put it or not into her bag is immaterial. She has the possession at the moment they caught her. So judges would normally, lower courts will look at the facts rather than the rules. Another one would be fact skeptic. Yeah, fact skeptic is the one looking at the rules rather than the facts. This is more applied towards the higher courts or appellate courts, whereby when it comes to appellate courts, they don't look at the facts, they are looking at the rules. Yeah? What is the rules? Those are the guidance for them in order for them to make decision. Kalau kat bawah, dia akan tengok the facts. Kalau kat atas, they go on the rules. As you can see here, the court system, you know the pyramid, right? So if you have the higher courts, then they would have a fact skeptic, meaning they are looking at the rules. So we can put here, so it's more of a rules rather than here is rule skeptic, they're looking at the facts. Meaning looking at the fact. Okay. So that is the nature. You have to look at the reality. This is the reality of the court system. If your case goes to the court that is higher in nature, obviously they meaning the judges are going to be fact skeptic. You cannot be in a way that you want to look at the facts more as compared to the rules. They are looking at the rules. So cases that goes high up in the court system are technical nature. You know, you will see the issue of technicality is being discussed in the higher courts. It is not about the facts. So if you want to look at the facts, I mean judges are looking or concentrating on the facts. It's more towards the lower one. Doesn't mean that when I say that, when he said that, Jerome Frank, it is not denying altogether. Yeah, like for example, the upper courts is just looking at rules, not the facts. It's not that way. It is more towards looking at rules for the higher courts and more towards the facts towards the lower courts. Okay, so facts are not objective. It depends on what judges see or hear when witnesses testify. This is also different from one judge to another. Obviously, that is facts is subjective. Yeah, if it is subjective, then it is open to interpretation. Okay, this reality of courthouses have to be disclosed. Yeah, because without public knowledge of such a reality, the need for reform cannot be made. Meaning, if you are not able to understand the reality of the court system, the nature of the how the judges are going to approach your problem that you are facing, or you are giving the courts to decide, so it is going to be detrimental to your well-being, you know, because they, in a way, that the court system is an institution that is able to function in a very smooth manner. So it is just like macam factory lah. Yeah? It's just a factory where everything is in order, everything is meticulously done, and though there are subjective area where the judges can decide, so that is the only area that you have subjectivity. But other than that, it is very smart engine. It's something that is very fluid in nature. So in order for us to obtain or gain some leverage from the system, we have to understand the system. Okay, you guys, if you end up as a lawyer, you have to be aware of this. Okay, if you are not aware, then obviously your clients are going to be affected by your misunderstanding of how the courts work. The legal myth that he's saying is that it is a basic legal myth to think that law can relatively permanent and fixed. It is permanent and fixed. It is an organism. Yeah, it is changing, ever changing, because law deals with human affair. How can law be permanent when it is actually the targeting of it, or it deals with human affairs? It is absurd for us to realize or approximate certainty and predictability in law. Yeah, it cannot be in a position that say that everything is clear. Yeah, I can safely say that we are 100% going to win our case. No, it is up to the court and the process of the court and the function of the court, the jobs, the institution, you know, and the intention, the Batman theory of the law from the judicial opinion system. So everything plays a very important role in order for uh, uh, certainty, yeah, to happen. But the thing is that he says that why people are looking for certainty, because we are in the position that it is our psychology, because we cannot we want something of a definite answer, but it's not, you know, like a child who cannot avoid for the need of authoritative father. So the father doesn't mean that they are going to do something that is satisfactory, you know, something that is for the happiness of that particular person. So you have to be mature in order to understand how legal system actually works. Because as I already mentioned earlier in the first slide, everything is about law that is being made by judges. So human does try to find in law a substitute for attributes like firmness, sureness, and certainty, which is like something that susah lah kita nak cari, but we try to look at the judiciary is something that is very, very rigid, fixed, and the ability for you to really find justice. But actually, therefore, man is always biased, because he has perception. Bila you ada you have perception over something, you 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 cannot control that thing, but you anticipate, you hoping, that is always biased, and therefore no one have ever a fair trial, and no one will, because if you do not realize that situation, obviously you are not going to be able to get a fair trial, and obviously you will be frustrated with the judiciary, because judiciary have a function that they have to do. Uh, yes, they are doing in a way that it is for justice of the society, but obviously it does not reflect that they are wrong people, they are bad people, they do not know what they are doing, which is against what I said just now. They know what they're doing. They are good people. They are people who knows what they are doing because they are experienced. So you have to be aware of that situation. And the last slide here is that justice is what the judge ate for breakfast. You don't play around with judges. Judges has already some decision that they has made over their cases, because they are human too. If they are not happy with their food that they are eating, it can reflect to your decision, to your case, your decision. Out of my own experience as trial lawyer, I can testify that the trial judge, because of overeating at lunch, may be somnolent, tired, sleepy in the afternoon court session, that he fails to hear the important items of testimony, and so disregards it when deciding the case. Human beings, that is the reality. So you have to be aware, even though that particular case is a good case, it might not be favoring you, because the judge did not realize that, or look that, because of that particular situation. The way one dress, skin color, ni saya punya additional. The way one dress, skin color, status, attitude, behavior affects a judge response to his or her case. Kalau you tengok when we go to Syariah court, then those people yang tak pernah pakai tudung, tak pernah pakai ketayak, songkok akan pakai songkok. Why? Because the impression that they want to do in order to influence the judge to favor towards themselves. That is the nature of things. People who wants to convince the judges to be favoring themselves, but the judge in a way can be influenced, but in certain situation, like what I saw a video last night regarding this particular judge. Memang dia this particular man, he's like 60 years old. His wife ada care home, taking care of the children. He raped 2 years and 4 years children, girl. So when he came to the judge pula perempuan, he kena belasah gila, sentence for life. That is the situation of American realism. Just to recap, what American realism is, to look at the reality of the judiciary. They are the one that is making the decision, because they are experienced, because they have a job that they have to do, because they have a mission for them to settle the case as soon as possible with the ability that is given to them. So we cannot force the judges to do the decision, even though we can set KPI and so on. But still, at the end of the day, it is up to the judges to make their own decision based on their persuasive or the intention that they have, which is to settle the problem at the same time by utilizing their expertise. So if you look at higher cases, chances of cases to settle early or faster is something that is based on how do they see things. Kalau yang lower one, you can see faster decision making. The upper one is not that fast because of the nature of the courts. Have to go through the what they call it rules, yeah, in order for them to decide the favoring the opposition or the plaintiff or the defendant or whatever. Okay, the parties involved. So guys, thank you so much. Baru nak masuk. Masya Allah. Muhammad, baru masuk ke? Orang nak habis dah. Right. Guys, I think that's it. The recording I will be able to give you as soon as possible. Petang ni, what I want to do is for you to go through the slide and for us to compare and contrast between Scandinavian and American realism. So Scandinavian realism dengan American realism is an area that you have to master in order for you to be able to answer your exam question. Yeah, I don't know whether comparative jurisprudential perspective is coming out or not, but to play safe, which I have no idea what is the question coming out, so we need to prepare. You need to differentiate between Scandinavian and American. American is very clear, straightforward, but do you know the differences? Then we will try to do a passing question. So try to find out the passing question in order for us to test, yeah, to test ourselves, our understanding. Okay, guys. So thank you so much for coming. So this is going to be recorded, alhamdulillah. Thank you. So see you this afternoon, inshallah.
Terima kasih, sir.
Thank you.
Thank you, sir.
Assalamualaikum.
Thank you,
Thank you,
sir.
sir.
Thank you.
Thank you,
Okay.
sir.
Welcome. Okay, everyone have to sign out. You have to get out, yeah, supaya I punya recording can end properly. Nurul Izzah, Hana, Sofia, Azehan, and Shazana. Shazana dah keluar. If you don't, then I have to remove you.